So by now, most people are aware that the principle of birthright citizenship started in San Francisco's Chinatown. But what many don't know is another Supreme Court ruling 10 years earlier actually established the foundation for the civil rights struggle of the 1960s. John Ramos shares with us a little-known piece of AAPI history at the center of the political struggles in our nation today.
We often think that the struggle for equal voting rights began with Dr. King in the 1960s, but it actually began 140 years ago with a Chinese immigrant at this parking lot in San Francisco. And it turns out that fight is still going on today. On this afternoon, a commemoration was held at the corner of 3rd and Harrison Streets, which is now just a parking lot. But almost exactly 140 years ago, there was a Chinese laundry here called Yik Wo that ran afoul of local ordinances and changed America as a result.
As is today, you have to be in the neighborhoods. So the Chinese were scattered all over.
In 1886, the city had passed a law that said you couldn't operate a laundry made of wood without a permit. David Lai with the Chinese Historical Society of America explains what happened next.
So 320 laundries immediately applied for this application. 100 got their permits, 220 rejected.
Not a single Chinese applicant was approved. So the owner of Yik Wo refused to pay a $10 fine and took the case all the way to the U.S. Supreme Court. Despite the rampant racism of the day, the justices ruled that the law violated the 14th Amendment's Equal Protection Clause, based not on what it said, but how it was being administered. Before he retired in 2018, Justice Anthony Kennedy spoke with a group of law students about the historical meaning of the Yik Wo ruling.
It says that even though the law is valid or neutral, fair on its face, if in application it's being applied in order to hurt a particular race, it's void. That's a tremendously powerful principle, and that's why the Yik Wo case is cited today.
In fact, the ruling became the basis for most of the legal challenges of the civil rights movement, culminating in the Voting Rights Act of 1965. But Professor Matthew Coles at UC Law San Francisco says the very premise of the landmark Yik Wo ruling is now being challenged.
But the Supreme Court, at least at that point, had the good sense to understand that you don't just look for statements of intent, you look at results. And the results here seemed very, very clear. If you were Chinese, you couldn't run a laundry. If you weren't, you could. What makes this moment, I think, particularly poignant is the Supreme Court just decided in a voting rights case that you can't prove a violation of the Voting Rights Act unless you can prove intent.
As a result of the court's recent ruling, states across the nation are rushing to redistrict their voting maps, being careful not to state what the real intent may be.
So immediately, Louisiana, Alabama, Tennessee, Mississippi, all decide that they're going to redraw their congressional districts. You know, it doesn't take a genius to see what's going on. They're going to get rid of the districts that have been electing black people to Congress.
The Yik Wo case may be 140 years old, but the argument behind it still rings true in 2026.
And I think what it tells us is in the late 19th century, the Supreme Court seemed to understand discrimination and the way it works a lot better than our Supreme Court does today.
Yesterday, May 10th, marked the 140th anniversary of the Supreme Court's ruling. Members of the Chinese Historical Preservation Society would like some kind of a memorial to mark the site where equal protection under the law was extended to everyone.